Have you ever wondered how judges and magistrates decide on the sentences they pass? The sentence should fit the crime, but what else should it achieve?
Our guide to sentencing shows how the decision-making process works and then gives you an opportunity to pass sentence yourself.
These offenders have each been charged with a criminal offence and are waiting to hear their fate. The scenarios are based on real-life cases.
You will hear the evidence and then decide on the sentence.
Afterwards, we'll tell you exactly what sentence they received and why.
How will your sentence compare? You be the judge.
Mr. Jackson, on May 15th, having entered as a trespasser the dwelling at 47 Dean Lane, you stole therein an engagement ring, other jewellery and a laptop computer. Do you plead guilty or not guilty?
Not guilty.
Most criminal cases are heard in a magistrate's court. The more serious cases are tried in the Crown Court by a judge and jury. In this case, Alex Jackson has pleaded not guilty, so a trial will take place and a jury will be asked to decide if he is guilty or not guilty. If they find him guilty, it is for the judge to decide on an appropriate sentence. As court clerk, I manage the court on behalf of the judge during the trial, though I'm not a lawyer. This includes preparing the judge's papers and keeping a record of the proceedings. To get the background on this case, let's hear some of the evidence given during the trial, first from the police officer and then the witness.
I was called to attend at 47 Dean Lane at 3 a.m. We arrived at the premises to find the kitchen window had been forced open and the ground floor had been ransacked. The occupants, Mr. and Mrs. Parker, had been asleep upstairs with their young baby in a separate room. Mr. Parker reported hearing a loud noise and went to investigate. He disturbed the intruder, who ran off.
I came downstairs to see what the noise was and saw the defendant run from the lounge into the kitchen. I took one look at the chaos downstairs and went straight upstairs to tell my wife what had happened. We were both really shaken up and she was scared something might have happened to our daughter. He took about £5,000 worth of valuables, including my mother's engagement ring, which was one of the few things I had left of hers. It wasn't worth a great deal, but I had planned to give it to my daughter someday. My wife's still really scared after the burglary and won't stay in the house on her own. When I work nights, she takes the baby and stays with her sister.
Will the jury foreman please rise? Have you reached a verdict?
Yes.
Do you find the defendant guilty or not guilty of burglary?
Guilty.
During the sentencing hearing, the judge will consider the seriousness of the case and the offender's circumstances. One of the documents before the judge is Alex Jackson's pre-sentence report. This has been prepared by his probation officer and provides relevant information about his background and the risk of him reoffending.
Your Honour, I draw your attention to the fact that Mr. Jackson has 2 previous convictions for domestic burglary.
Your Honour, I represent Mr. Jackson. Mr. Jackson has been a heroin addict for over 5 years, although he is now on a rehabilitation programme. On the night in question, Mr. Jackson was suffering from acute withdrawal symptoms. It was obviously an act of considerable desperation to break into a property that was occupied at the time. Since his arrest, Mr. Jackson's former partner has agreed to take him back on the condition that he addresses his addiction problem. I can confirm that his treatment is progressing well. Mr. Jackson recognises the acute distress he must have caused to Mr. and Mrs. Parker and wishes to express his sincere apologies. The recent birth of his baby daughter has been a real wake-up call for Mr. Jackson. He says he owes it to her and his partner to get his life sorted out.
You've heard the arguments. Now it's time for you to be the judge.
Please stand, Mr. Jackson. You have been found guilty of burglary. The sentence of this court is... You've been convicted of burglary. As we heard from Mr. Parker, the stress that you have caused him and his wife has been immense, and you have left them in a state of constant fear and anxiety. Had you pleaded guilty, then that would have been a matter I could have taken into account in your favour. However, since you have not, and as you have 2 previous convictions for domestic burglary, I must impose the mandatory minimum sentence of 3 years imprisonment. The fact that it was carried out late at night, whilst the householders were in their beds asleep, is an aggravating factor. To your credit, you're making constructive efforts to overcome your addiction problem. However, it would not be right for this court to set that positive development against the misery that you've caused Mr. and Mrs. Parker. Your offence merits a prison sentence. Therefore, I sentence you to 3.5 years imprisonment.
In this case, Alex Jackson's loss of liberty is clearly a punishment, but it also protects the public from further criminal acts. For a 3rd offence of domestic burglary, the law requires a judge to give a minimum 3-year prison term, other than in exceptional circumstances. Alex will be able to continue his drug programme while he's in prison. The law says that it's not just the monetary value of goods that influences the sentence given, but also their sentimental value. And that concludes this case. Whether or not you agreed with the sentence given, I hope you've discovered that there's more to sentencing than meets the eye.
Some offences can be dealt with in the Magistrates' Court or the Crown Court, but a serious offence, such as a street mugging committed by an adult, which in court is categorised as a robbery, is always heard in a Crown Court. As a court clerk, I manage the court on behalf of the judge during the trial, though I'm not a lawyer. This includes preparing the judge's papers and keeping a record of proceedings. Mr. Roberts, on the 17th of December, you robbed Miss Gillian Hunter of £75 in cash, credit cards and a mobile phone. Do you plead guilty or not guilty?
Guilty.
As Mr. Roberts has pleaded guilty, there is no need for a trial with a jury. A date will be set for a sentencing hearing when the judge alone will decide the sentence. To determine the most appropriate sentence, the judge will have to decide how serious she considers the offence to be. To assist her, she will ask the prosecution barrister to set out the facts of the case and draw her attention to any aggravating factors. The judge will also consider the mitigating factors raised by Andrew Roberts' barrister. She will consider a pre-sentence report prepared by a probation officer which covers Mr. Roberts' background, the risk of harm that he represents, and the likelihood of him committing further crimes. The judge will also take account of the sentencing guidelines for robbery.
Your Honour, on the night in question,
Miss Hunter was walking home at about 12:20 when she was grabbed from behind by an adult male, later identified as Mr. Andrew Roberts. He dragged Miss Hunter into the side alley of her house and threatened her by holding a knife to her throat. She was forced to hand over her handbag, which contained her house keys and mobile phone. Her attacker then ran off. Obviously in a distressed state, Miss Hunter alerted a passerby who telephoned the police. The offender was arrested in the vicinity and found to be in possession of Miss Hunter's mobile phone and bank cards taken from her purse.
The judge will now hear arguments from the defence concerning any factors she should take into account that might reduce the sentence, so-called mitigating factors. These might relate to the nature of the offence or personal circumstances of the offender.
Your Honour, Mr. Roberts fully acknowledges the gravity of his crime and cooperated fully with the police following his arrest. He entered a guilty plea at the earliest possible opportunity. Mr. Roberts has no previous convictions, but he is a long-standing drug addict, and he carried out this robbery to feed his drug habit. He wishes to express his profound remorse for the distress he caused to Miss Hunter.
You've heard the arguments. Now it's time to consider your sentence. Judges have the benefit of detailed guidelines to help them decide on the appropriate sentence. So let me give you some hints. In most cases of robbery, an adult offender is likely to receive a prison sentence. For this type of street robbery, the guidelines suggest a starting point of 4 years imprisonment. As the judge, you need to decide whether to increase the sentence because of the aggravating factors in the case, and whether to decrease it due to the mitigating factors, and any discount for an early guilty plea. Now it's time for you to be the judge.
Please stand, Mr. Roberts. You have pleaded guilty to robbery. I sentence you to Robbery is an extremely serious offence. To attack a young woman in the dark and put a knife to her throat is utterly deplorable. She would have been terrified. The fact that you are a drug addict cannot possibly excuse such behaviour. The fact you didn't harm your victim with the knife does not make the offence less serious. I consider your use of a weapon and the fact that the offence was committed at night on a vulnerable victim to increase the seriousness of the offence. In your favour, I note you do not have any previous convictions. I also note you made a plea of guilty at the earliest opportunity. In doing so, you have at least spared your victim from having to relive her experience in court, and you will receive a discount of 1/3 for that. I sentence you to 4 years imprisonment.
So, Andrew Roberts has been sentenced to 4 years. In this case, the judge reduced Andrew's sentence by 1/3 for his early guilty plea, and then added to the sentence for the aggravating factors, his use of a weapon, for example. That resulted in the sentence of 4 years. This means he will spend 2 years in prison and the rest under the supervision of the probation service. If he breaches the conditions of his sentence while in the community, he is likely to find himself back in prison. It's a sad fact that a significant number of robberies are committed by addicts who steal to buy drugs. While he's in prison, Andrew will receive help to address his drug addiction. And that concludes this case. I hope this helps you understand how sentencing decisions are made. But why not try another of our cases?
Welcome to the Crown Court. I'm the court clerk and I manage the court on behalf of the judge during the trial, though I'm not a lawyer. This is the murder trial of Connor Davies, who's charged with the murder of 89-year-old Arthur Ramsey. Most cases take place in magistrates' courts, but more serious cases like murder take place here in the Crown Court. As Mr. Davies has pleaded not guilty to the offence, there will be a trial. Whether he is found innocent or guilty will be a decision made by a jury of 12 people from the local community. At the end of the trial, if he's convicted, it will be the judge and you who decide on the sentence. But as a prospective judge, tell me this. If he is found guilty, what effect would his original not guilty plea have? But first, let's see a summary of the key facts of the case.
The Crown will show, in April last year, that 89-year-old Mr. Ramsey answered the door to Connor Davies. Mr. Ramsey was a frail old man who had recently suffered a stroke. In order to gain access, Mr. Davies lied. He said he needed to use the telephone and wanted to borrow some cash to visit his pregnant girlfriend in hospital. However, once inside, he attacked Mr. Ramsey with Mr. Ramsey's own walking stick. He pushed his head so hard into the wall that it left this hole in the plaster. He then kicked Mr. Ramsey in his head at least 3 times and kicked and stamped on his throat. He then gripped Mr. Ramsey tightly around his throat. As Mr. Ramsey lay motionless on the hallway floor, Mr. Davies stole £50 from his wallet before calling his drug dealer and then a taxi.
How was Mr. Ramsey when you left his house?
I think I must have shocked him. He just fell over. I panicked and left the house. He seemed okay then.
We maintain that that is a lie. In all, Mr. Ramsey suffered injuries to 15 parts of his body, internal bleeding around his brain and damage to his larynx, indicating he had been strangled by his attacker. Mr. Davies' fingerprints were found inside Mr. Ramsey's home, and Mr. Ramsey's blood was found on his trainers. Mr. Ramsey was found the next day by his carer and died 26 days later in hospital.
In his defence, Connor Davies accepts he had intention of burgling Mr. Ramsey's house, but he had no intention of harming him when he entered.
Do you find the defendant guilty or not guilty of murder?
Guilty. If counsel would like to address the court of matters relating to sentencing. As the jury have fulfilled their responsibilities, they're free to go. We will now hear the prosecution set out the factors that could increase the offender's sentence. These are called the aggravating factors, while the defence will then focus on the issues that can decrease the sentence, the mitigating factors.
This attack was of unrelenting ferocity on an elderly and vulnerable man. It was deliberate and repeated and likely to lead to death. At no point has Mr. Davies expressed remorse or regret.
Mr. Heskins, if the defence could raise any mitigating factors?
My client has always admitted to burglary. The death of Mr. Ramsey was a tragedy, but he never meant to kill him. At the time of the attack, my client was suffering from a mental disorder induced by drug and alcohol use, which meant he panicked.
Murder is the most serious of criminal offences. It always receives a life sentence, which lasts for the whole of the offender's life. And while serving this sentence, the offender may be considered for release from prison after a set period, called the tariff, has been served. However, if released, the offender will be on licence and monitored in the community for the rest of their life. Some offenders are not released until well after the tariff expires, and some will never be released. So, what I need to do in this case and what you will need to consider is what the tariff should be. Mr. Davis, you have been found guilty of murder. The law requires me to impose a life sentence. I must set the minimum prison term you will serve. This is called the tariff. Only after you have served your full tariff will you be considered for release by the parole board. You will only be released if, on the basis of a stringent assessment by the parole board at that time, you are no longer deemed to pose a risk to the public. Should you then be released, whenever that is, you will not be free of your sentence. You will remain on licence for the rest of your life. You will be supervised by the probation service. You may be recalled to prison at any time for breach of your licence conditions or for any further offence. I must set your tariff in accordance with the guidance set out in Schedule 21 of the Criminal Justice Act 2003. Schedule 21 from the Criminal Justice Act of 2003 provides guidance on how to set a starting point for a tariff in a murder case. The possible starting points are 15 years, 25 years, 30 years, or whole life. And once you've chosen the starting point, you will want to consider the seriousness of this case and any aggravating and mitigating circumstances you think should increase or decrease the tariff. So, with those in mind, what final tariff would you set? Connor Davis, you have viciously attacked and murdered a vulnerable old man who posed you no threat at all. The fact you phoned your drug dealer after the attack shows a callous disregard for Mr. Ramsey's life. You have not shown the slightest indication of remorse or regret for what you have done. Your defence counsel urged me to make allowances on the basis that you did not intend to kill. I do not attach any weight to that argument. You acted in such a way as to have no regard to the welfare of Mr. Ramsey. I consider the starting point for this type of case to be a 15-year tariff. However, the presence of a number of serious aggravating factors mean that I increase that tariff. You must have known that the violence you inflicted upon him would put his life at risk. If you did not actually intend death to result, you intended very serious injury, and were in reality completely indifferent as to whether death resulted or not. I also give no weight to your claimed state of mind as a result of alcohol and drugs use. You chose to be intoxicated, and far from excusing your behaviour, I consider that to be an aggravating factor. You will serve a minimum period of 25 years in prison. Take him down.
So there you go. Connor Davis received a life sentence with a 25-year minimum prison term. He'll be 55 by the time he's even considered for release by the parole board. He may never be released, and even if he is, he'll be monitored for the rest of his life. And that concludes our case. I hope you found it interesting, and if you did, why not try another one?
Welcome to the Crown Court. I'm the court clerk and I manage the court on behalf of the judge during the trial, though I'm not a lawyer. This is the trial of Rebecca Edwards on the charge of possessing ecstasy with the intention of supplying to others. We must now hear the defendant's plea. Rebecca Edwards, how do you plead?
Guilty.
Rebecca Edwards has pleaded guilty to the charges, so we won't need a trial to determine if she is guilty. She's already admitted it. Most cases take place in a magistrate's court, but because the supply of illegal drugs is so serious, it's being held here, in the Crown Court.
Rebecca Edwards, you were apprehended by police in a nightclub where you had on your person over 300 ecstasy tablets. These are categorised as Class A, and as such are the most serious class of illegal drugs. It is my job to determine how much harm you intended or could have caused, along with the role you played in the supply of these drugs. I must also consider how much you stood to gain financially. Counsel would like to address the court on matters relating to sentencing. We will now hear the prosecution set out the factors that could increase the offender's sentence. These are called the aggravating factors, while the defence will then focus on the issues that could decrease the sentence, the mitigating factors. Mr. Lewis, for the Crown.
The offender admitted that she entered a nightclub with the express intention of selling over 300 ecstasy tablets, for which she intended to make a considerable profit. This is a significant amount of a Class A drug which had the potential to cause considerable harm. The offender was also trying to dispose of the drugs by flushing them down the toilet when she was caught. Now, this amounts to trying to conceal the evidence from the police.
Ms. Williams, if the defence could raise any issues of mitigation.
My client ran up significant credit card debts, and in order to pay these off, she obtained a loan from an unlicensed lender with punitive high interest rates in the local neighbourhood. When she failed to pay these off, she found herself working for the lender's associates selling drugs. This crime was therefore committed under some financial stress. My client is 28 years old, is unemployed, and has no previous convictions. She is a single parent and the sole carer for her daughter. Neither the father nor other relatives are in the proximity, so a custodial sentence for the mother would be devastating to the child, as she will need to go into local authority care. She also entered a guilty plea at the earliest opportunity. She should therefore receive the maximum reduction of 1/3 off her sentence. She has avoided the need for witnesses to attend a trial and has saved prosecution and court time and expense as a result of her guilty plea.
Rebecca Edwards, I must now pass sentence. You have pleaded guilty to possession with intent to supply Class A drugs. The maximum penalty for this offence is a life sentence. I must follow the sentencing guidelines for this offence. The Sentencing Council has issued a set of guidelines that all judges must follow when sentencing cases like this. The guidelines state that I must follow a set process in reaching my sentence using a number of steps. The first point to consider in determining the seriousness of the offence is what their role in the drug trade was and the amount of drugs involved, which helps me identify the harm they inflicted or could have inflicted. I am persuaded that Rebecca Edwards was not directing or buying on a commercial scale or operating in a managerial capacity, though she was acting solely for financial gain. On the evidence presented to me, I find that she was performing her role under some pressure, though this was largely due to her own making. This places her in a lesser role. I must now consider the amount of drugs involved. Rebecca had over 300 tablets. This places the amount of drugs in category 3 out of 4. Following my consideration of the offender's role in the drug trade and the amount of drugs involved, I am now able to set the starting point. This is a starting point of 3 years imprisonment, but with a range of sentences of between 2 and 4.5 years. I will now consider whether there are any aggravating or mitigating factors that would result in an increase or decrease in the final sentence. I bear in mind that Ms. Edwards has no previous convictions. I'm also very mindful of the offender's daughter in this case. I have to balance that against the fact that the supply of Class A drugs is a very serious offence and that she attempted to conceal evidence. These factors persuade me that the sentence should be increased above the 3-year starting point. However, I must also take into account the offender's early guilty plea. As she has not only pleaded guilty in court at the first available opportunity, but made admissions to the police, I will allow the maximum reduction of 1/3 of the final sentence. But as a prospective judge, what sentence would you give? Rebecca Edwards, for the reasons I have outlined, I'm giving you a 3-year sentence.
So, Rebecca Edwards received a sentence of 3 years. That means that she will spend half of that sentence in prison and half under the supervision of the probation service in the community. Her child will be referred to social services until she is released. And that concludes our case. I hope you found it interesting. If you did, why not try another one?
Welcome to the Crown Court. I'm the court clerk and I manage the court on behalf of the judge during the trial, though I'm not a lawyer. Most cases take place in the magistrates' court, but serious cases like manslaughter take place in the Crown Court. The defendant, David Chichester, has pleaded guilty, so we'll go straight to his sentencing hearing. We'll tell you the facts of this particular case, which, as you'll see, raise some very difficult sentencing issues, even for experienced judges. Now, let's recap what happened. David Chichester had just finished a job when his car was scraped.
What have you done? You hit my car! Come back!
He was incensed. The driver sped away.
Look, pull over, mate.
The driver wasn't going to stop. David Chichester was definitely angry.
Are you blind or something, mate? Your car just hit my car.
I didn't hit your car.
What? I'm just angry.
Crazy.
And then he hit the driver. Did the driver realise he'd scraped the car? We don't know. Unfortunately for the victim, John Goff, he never regained consciousness and later died. My lord, we're ready for you. Today, the case of an involuntary manslaughter.
Ah, yes, one of those tricky ones. Involuntary. Where the offender has no intention to kill, but the death was the result of an unlawful act like a punch or a push.
As opposed to voluntary?
Yes, where the offender may have intended to kill, but the crime is reduced due to provocation.
Why is this case so tricky?
Well, as with all involuntary cases, we need to consider what the accused actually intended to do, and not exactly what he actually did. But you have to understand that the victim was killed as a result of the violence. But on the other hand, you also have to understand the fact that the offender didn't intend to kill.
We will now hear the prosecution set out the factors that could increase the offender's sentence. These are the aggravating factors, while the defence will then focus on the issues that can decrease the sentence, the mitigating factors.
Mr. Johnson, for the Crown.
This attack was predetermined in nature. The accused was actively in pursuit of the victim, Mr. Goff, and intent on inflicting violence upon him. When Mr. Chichester confronted the victim, he shouted at him in a threatening way, and then he punched him. The force with which he struck him was so great that Mr. Goff instantly fell to the floor and later died.
My client has always admitted to unlawful violence. I would argue that you should consider that it was the victim's careless driving that caused him to collide his car into my client's vehicle, thereby provoking my client's aggression. He also entered a guilty plea for manslaughter at the earliest opportunity. I would also stress that this attack is completely out of character. As testimonials, character witnesses and references show, at the age of 56, David Chichester has an unblemished record, with no previous conviction whatsoever. My client accepts he punched Mr. Goff and that he should not have done so. But he never intended or expected that this would result in Mr. Goff's death.
David Chichester, I must now pass sentence. You have pleaded guilty to manslaughter. The maximum penalty for this offence is a life sentence. This is a death that resulted from a single punch. Now, there is no sentencing guideline for this offence, but I am guided by the guideline of the Court of Appeal. A case such as this will normally result in a prison term, but I keep in mind that this is not a murder case and should not be treated as one. I have to balance the relevant aggravating and mitigating factors in this case. But before I explain my sentence, what sentence would you give? David Chichester, in determining the seriousness of any offence, the court must consider your culpability. In other words, your knowledge and intention of committing the offence and any harm which the offence caused, was intended to cause, or might foreseeably have caused. You should have known that the violence you inflicted upon John Goff could put his life at risk. I accept, however, that you did not actually intend death to result. But acting in this violent way is simply unacceptable. The harm you have inflicted is the highest imaginable. I should make clear that I give no weight to the suggestion of mitigation from any provocation by Mr. Goff's car scraping your vehicle. This is not an excuse for the act of violence you committed. I am mindful that this is your first offence and that the violence you imposed was out of character. And I have taken account of your early guilty plea and have reduced your sentence by a third. For these reasons, I'm giving you a sentence of 2.5 years.
So, David Chichester received a sentence of 2.5 years. That means that he will spend half of that sentence in prison and half on licence under the supervision of the probation service in the community. But he will serve the full sentence. While on licence, if he commits another offence or breaches the terms of his release, he may find himself in prison. So, that concludes our case. I hope you found it interesting. If you did, why not try another?
Mr. Williams, on November the 19th, you acted in a threatening way, putting Mrs. Emily Dixon in fear of physical violence. Do you plead guilty or not guilty?
Guilty.
In magistrates' courts, cases are generally heard by 3 magistrates who are ordinary members of the community, trained for the role. My job is to advise them about legal matters, including the sentencing guidelines. In this case, the magistrates needed more information about the offender's background to confirm their initial view, so they asked the probation officer to prepare a pre-sentence report. We rejoin them at the sentencing hearing.
Mr. Williams, you have pleaded guilty to the charge of threatening behaviour. We will now hear the facts of the offence before passing sentence.
You rang about a disturbance at around 6:30 this evening. Can you tell me what happened?
Chris Williams and his friends were down the road kicking their football at people's dustbins, knocking them over and making a lot of noise. I called out from my front door, but he didn't take any notice. So I went up to my front gate and told him to stop making a nuisance.
Did you say it in those words?
No, I told him exactly what I thought. I said they'd turned the estate into a slum and they should either get a job or be locked up.
So, what happened then?
He ran up to me and shouted at me. He was this far away from my face. He said, "Why don't you F off, you nosy old bitch?"
Anything else?
Then he said, "If you don't shut your mouth, I'm going to punch your effing lights out." I thought he was going to hit me.
I'm led to believe that you swore at Mrs. Dixon and threatened her physically when she asked you to stop creating a disturbance.
She came out and started shouting at us from down the street. We ignored her because she's always on our case and we didn't want any trouble. But then she came over and gave me a right mouthful.
In her statement, she says that you put your face up to hers and said you were going to punch her effing lights out. Is that right?
I can't remember what I said, to be honest. But we were just minding our own business, playing football. She was the one who came over and started mouthing off, saying we should be locked up.
Mrs. Dixon felt extremely threatened by your aggressive behaviour and the language you used.
She's always calling us yobs and stuff. There's nothing to do round here. I was just hanging out with my mates. That's not a crime, is it?
But threatening behaviour is a crime.
Yeah, I did threaten her, but I didn't want to scare her. I know it was a bit over the top, but I just wanted her to leave us alone.
I would remind your worships that the victim has been considerably affected by this incident. She said in her victim personal statement,
"It's made me a nervous wreck. They've made my life a complete misery. The noise has been constant, day and night, especially during the summer. I can't bear going out of my front door anymore."
My client, Mr. Williams, has no previous convictions. He entered an early guilty plea and has expressed remorse for his behaviour. In addition, he has agreed to apologise to Mrs. Dixon in person for what he describes himself as an over-the-top reaction. He would like now to express his remorse to the court.
You've heard the arguments. Now it's time for you to be the judge. Please stand, Mr. Williams.
You have pleaded guilty to threatening behaviour. The sentence of this court is... Mrs. Dixon is elderly and vulnerable. Causing her to fear immediate violence was a serious offence. We've taken account of the impact of your behaviour on her, as she expressed in her witness statement. We do not consider this offence to be serious enough for a prison sentence, but it does deserve a community sentence. Although it was an impulsive action, and you may have felt that you were to some degree provoked, this is not an excuse. We noted that you had no previous convictions. We also noted that you pleaded guilty and that you have shown genuine remorse, for which we give you credit. Taking all these factors into account, we're sentencing you to a community sentence with a requirement that you carry out 80 hours of compulsory unpaid work. We also order you to pay Mrs. Dixon £100 in compensation, along with court costs of £90.
So how does this compare to your own sentence? Chris Williams, pleading guilty at the start, avoided Mrs. Dixon having to give evidence in court. For this reason, his sentence was reduced to 80 hours, rather than the 120 it would otherwise have been. If Chris breaks any of the requirements of his sentence, it may be increased, or he may be resentenced, which could involve going to prison. Unpaid work, such as doing up the garden of a retirement home, is punishment as well as a way for Chris to make amends. This is why it's often called community payback. And having to pay compensation to Mrs. Dixon out of his unemployment benefit, in addition to court costs, will remind him of the considerable distress he's caused her. And that concludes this case. I hope we've shed some light on the thinking behind sentencing decisions.
Welcome to the Youth Court. This room is rarely seen outside of cases as it has no public gallery and operates a lot less formally than adult courts. I'm from the Youth Offenders team, often referred to as a YOT or YOT. My role in this court is to offer advice and to liaise between the youths appearing in the court, their parents or guardians, the court representatives and their lawyers. Whilst I'm not legally qualified, I do have relevant experience and qualifications in youth justice. I must make myself acquainted with the defendant and the case before it starts, which allows me to discuss the case knowledgeably with the district judge or lay magistrates. So, as a starter question, what would you say should be the main aim of sentencing for young offenders? Actually, our main goal is to rehabilitate the young offender and to stop them reoffending. Hi, Robert. Hi, Jenny. Ready to go? This way. While we go to the court, why don't you acquaint yourself with the facts?
Okay.
The incident occurred after school.
What the hell? Give it to me!
Nice.
I'll give it you, it's a present!
The new one? Present for me? I bet you have lots of money for me as well, don't you?
Give it!
Don't you?
Robert, this is a very serious case. You understand that?
Yeah.
Your actions were caught on CCTV, and you've accepted that you are guilty. Is that correct? But you do understand that threatening violence to another child while you stole from him is a serious offence. You're 15, but you've been in trouble since you were 12 years old. Stealing from the corner shops, shouting and swearing, then throwing bricks at a shop window. You've received a number of formal warnings and been made to do reparation. You're also truanting from school. Why are you behaving like this?
I promise it won't happen again.
Do you understand the effect that your behaviour is having on your latest victim?
I'm really sorry.
The boy is too afraid to go to and from school and go out on his own. In sentencing Robert, I have to consider all the aggravating and mitigating factors put to me by the lawyers.
I would like to emphasise that the victim was considerably smaller than Robert, and the robbery was aggravated by the threat of violence. Now, as we saw from the CCTV footage, that threat was very real. Robert did indeed steal the victim's phone and his money. The victim is now too scared to go out on his own, and his schoolwork is badly affected. It appears that Robert's behaviour is getting worse, and he's moved from shoplifting to the much more serious offence of robbery. Had he not have been recorded on CCTV, he may not have been caught, leaving him free to victimise others.
Thank you, madam. In mitigation, I would like to point out that Robert is just 15 years old, still has much to learn. He lacks a father figure, and his mother is having difficulty controlling him. As a consequence, he appears to have fallen under the influence of some older boys. Even though he is immature for his age, he's pleaded guilty and fully understands that threatening violence towards the other boy was extremely serious. However, he did not use a weapon of any kind.
Those were the arguments from both sides. So, how would they affect the sentence you give?
And now I'd like to hear from the youth offending team representative, please, on possible sentencing options.
Robert has complied with his previous sentences, but they have not successfully changed his behaviour, which has now got worse. A large part of the problem is that he has now been led astray by some older boys. There are a number of options that I can recommend to the court. Compensation and reparation. In other words, compensating the victim and making amends, either to the victim or the community at large. A fine. A youth rehabilitation order. In other words, a youth community sentence with requirements. Or a detention and training order. In other words, a youth custodial sentence.
Robert, I must now sentence you for the offence of robbery which you have admitted. I am going to explain to you the reasons for my sentence and what this means for you. Robert, you threatened violence to steal from a child who is much smaller than you. The effect on your victim's been very harmful. His education is suffering and he's scared to go out on his own. I believe you understand how serious this is. And it's to your credit that you've pleaded guilty and shown how sorry you are. Nevertheless, your behaviour is getting worse, even though you have carried out your previous sentences. It seems to me, therefore, that you now need some stronger controls on your behaviour to stop you reoffending. I am therefore giving you a youth rehabilitation order, which is a community sentence. As part of this, you must stay in your house every night from 7 p.m. to 7 a.m. for the next 3 months. You will wear an electronic tag, which will show if you're not at home when you should be. You will also be supervised by your youth offending team worker, so you'll have to see him regularly and he will help you to improve your behaviour. You're also required to attend school. If you do not follow these requirements, you will have to come back to court where I will consider a further punishment. Do you understand?
So, that concludes our case. I hope you found it interesting. And if you did, why not try another one?
Mr. Horton, at your trial you were found guilty of criminal damage. We will now consider your sentence.
In magistrates' courts, cases are generally heard by 3 magistrates who are members of the community, people like you and me. They oversee the trial and decide the sentence. My job is to advise them about legal matters, including the sentencing guidelines. But before we go any further, let's find out about the facts of this case. Robert Horton, on the 23rd of March, without lawful excuse, you damaged 3 vehicles and a garage door. Do you plead guilty or not guilty?
Not guilty.
I was woken in the middle of the night by some man shouting at the top of his voice. I looked out of the window and saw him staggering down the street. Then he looked like he was scratching something on the bonnet of a car. After that, he did the next one along.
So what did you do then?
Well, he looked like he was heading towards my car. So I opened the window and shouted at him to stop. At that point, he ran off. Then my husband and I went down to inspect the cars and saw scratches on the bonnets. That's when I called the police.
We arrived at the scene at 2:37 a.m. and found the defendant spraying graffiti on a garage door. On searching him, we found a key marked with paint. He clearly had a considerable amount to drink. We arrested him, and the defendant was subsequently identified by the witness at an identity parade. We estimate the cost of damage at £1,500.
Having heard the evidence, the magistrates found Mr. Horton guilty of criminal damage. At this hearing, the prosecution and defence solicitors will highlight factors which they think should affect his sentence. The magistrates will need to weigh up all these factors when considering their sentence.
Mr. Horton has a previous conviction for damaging property. He's clearly not learned any lessons from this, and your worship should take this into account in sentencing for this offence.
My client's previous conviction was 7 years ago and was committed when he was a juvenile. He has not reoffended since. In my submission, it is neither recent nor relevant and should not be given any weight in your deliberations.
I would remind your worships that the fact that Mr. Horton was drunk is neither a defence nor a mitigating factor in this case. As you're well aware, the guidelines state that committing an offence while drunk makes it more serious, not less.
I put it to you that this is not characteristic behaviour. He was drunk on this occasion because of a traumatic breakup with his girlfriend. I'm not suggesting that Mr. Horton being drunk should act in his favour. I am asking you to consider, as a mitigating factor, the personal issues that led him to get drunk in the first place. Your worships will have seen a letter from Stephen Bryant, Mr. Horton's employer, about his good character. Mr. Horton has held a steady job as a delivery man for over a year. If he received a prison sentence, he would lose his job, which would do nothing to help his prospects of rehabilitation.
Is there anything you want to say?
My girlfriend broke it off that night. I was gutted. Been with her nearly 2 years. I don't know what happened. I just lost it. It definitely won't happen again.
You've heard the arguments. Now it's time for you to be the judge. The sentencing guidelines for criminal damage set out 3 main options: a fine, a prison sentence, or a community sentence, which can include things like a curfew or unpaid work to offer payback to the community. There's another thing that will help you make your sentencing decision. Once a defendant has been found guilty, the magistrates often ask for a pre-sentence report to be prepared by the probation officer. The report provides background information that will help them decide the most appropriate sentence. The probation officer will have assessed the risk of harm that Robert Horton represents to the public, plus the likelihood of him committing crimes in future. The report would generally recommend a sentence, but I don't want to influence your decision. Please stand, Mr. Horton.
You have been convicted of criminal damage. We consider this a serious offence. The sentence of this court is... For the offence of criminal damage, we can impose a maximum sentence of 3 months in prison. The sentencing guideline categorises this offence as significant damage up to £5,000 and damage caused as part of a spree. The starting point for that is a medium-level community sentence and up to a short custodial sentence. Although the damage was deliberate and significant, we don't consider your offence so serious that only a prison sentence is justified. We do consider your offence serious enough to impose a community sentence. We have taken into account your previous conviction, but noted that it was for a single offence and committed some time ago. We took into account that you were drunk, which is no excuse for your actions. However, we have also borne in mind that your behaviour was uncharacteristic and prompted by the breakup of your relationship, and that you have shown genuine remorse. Weighing these factors, we felt your behaviour would be better tackled by way of a high-level community sentence. It'll give you the opportunity to put something back into your community. Given that you are employed, we have also added compensation to the victims of your crime to the sentence.
So, how did this compare to your own sentence? The magistrates obviously thought this was a serious crime. Unpaid work is punishment, as well as a way to make amends, which is why it's often called community payback. Cleaning up graffiti, for example, will be a good way for Robert to give back to the community. Robert will have to fit in his 200 hours of unpaid work on top of his day job, so he'll lose his weekends for some time. And for a young person, a 12-hour curfew puts a serious damper on his social life. Finally, having to pay compensation to his victims for the damage he caused will put a big strain on his entertainment budget. And that concludes this case. I hope we've shed some light on the thinking behind sentencing decisions. As you've seen, it's rarely clear-cut.